Excellent. Appreciate it. Thank you for getting that done over the lunch hour. Defense, are we ready to bring in our jury?
I've got a couple of issues.
Yes.
Number one, Kevin Beck is working on.
Let the record reflect that Mr. Beck has appeared.
For the record, I'd like to make 2 points about this issue, about whether or not I can bring in evidence of prior acts, prior bad acts, prior to the overt act. And there's 2 reasons that I believe I should be allowed to do so. One is, Judge, in that 2-minute video, Sarah Boone makes a statement, "That's how I feel when you choke me." And then some moments later, "That's how I feel when you cheat on me." And she's angry at him, and she's talking to him. She's talking to him in an intoxicated state, and she's expressing her anger and why she is angry. And I ought to be able to elaborate on what that is that she's angry about as it relates to when you choke me. That's my first motion.
Okay.
The second one is, Judge, on this.
Before you proceed with the second, is the second intertwined with the first?
No, I mean, it's a similar argument, but related to something else.
Okay, response.
Judge, I don't disagree that they should be able to bring that in once they've established an overt act that is imminently dangerous to an objectively reasonable person. I believe that's the law in our home.
Any other further arguments, sir?
Not on that issue.
Motion's denied. Court, again, is going to rely on the Supreme Court's guidance in these situations based on Holland 916 Southern 2nd 750 at point 760 through 761.
My second argument ties into what he just said about what a reasonable person would do under the circumstances facing an imminent threat, whether a reasonable person would perceive the overt act on the part of Jorge Torres that was witnessed by Sarah Boone. Would that be perceived by someone as a imminent threat? And to some degree, you have to understand the history of Jorge Torres and Sarah Boone. They were together 3.5 years. They were engaged, but there had been a history of violence. And from the evidence that's been presented, facing the circumstances in total, if you take what she said at various times, you would understand that she became concerned when he came back from Publix with that second bottle of wine, because she knew when Jorge Torres gets to a certain level of intoxication, he gets sad, he gets moody, and eventually he gets belligerent, and sometimes he can be violent. So she knew when he brought home that second bottle of wine that it was not going to be a good night, and she tried to keep him occupied and tried to keep his mind off of his troubles, because she knew that if he reaches a certain level and is dwelling on his hardships, that he will react to her in a violent way. So she had that state of mind with that understanding of her history and his history in his overt act, which she's going to testify to, coupled with the fact of her state of mind based on her past experiences with him in that intoxicated state and the fact that he is violent. So she was hypersensitive to danger and fear. And I think that ought to be allowed in as part of her collectively an overt act. So it was culminated by his state of intoxication coupled with his overt act created the well-founded fear for her to block the attack, to self-restrain or physically restrain Jorge Torres in the suitcase, to actually use the bat to prevent him from getting out of the suitcase, because she knew she was going to get attacked.
And the basis of the opinion of about to be attacked is predicated on the prior incidences of violence, correct? based on
Well, there's
her
an overt
knowledge?
act committed by George Torres, but she was heightened because she knows when he gets to that level of intoxication in that scenario, and that's an issue.
So I need clarification. What is it that you're asking me to do?
For me to be able to elicit from Sarah Boone that she was concerned once that second bottle was brought, and that's why she tried to placate him over the course of the evening, and that's why she had a heightened sense that he was capable, Judge, due to his degree of intoxication, that he may act violently towards her. And the problem is, a lot of the problem is, Judge, he doesn't remember battering her the next day. That's part of the reason that she videotapes him and photographs him. She starts to document what happens so that she can show him. She loves the man. She adores the man. She wants to marry him. She wants a life with him. But she's tired of being beat on, and so that all ties into her behavior, her sense of nervousness at that point. The reason she was so confident during that 2-minute video is because she knew, okay, this is my chance. He can't get to me. I can tell him exactly what he does that bothers me, that hurts me, and how I feel. And so that's all tied together with then he starts to try to get out of the suitcase, and she reacts the way she does.
Response.
We held these arguments already. The court has ruled. There are no new arguments being made. The court understands exactly what Sarah Boone, the defendant, said to Dr. Werner on October 2nd. The court knows exactly what the defendant said to Dr. Harper over the period of a number of months and years, and there was no overt act. The overt act has to be something that is objectively reasonable to cause a reasonable person to believe there's an imminent fear of great bodily harm or death. What the testimony is not that that's what has occurred, that there's, her new testimony is this generalized fear, but you've already read that and you've already ruled on that. And I'll just remind the court that her previous testimony is, it's all fun and games, we're laughing, I zipped the suitcase shut, we're still both laughing, it's funny, and then the decedent says, I can't breathe, and then she flips a switch, gets angry because it reminds her of all the times before where she is asserting that the decedent made her feel like she couldn't breathe, and then that's when she starts beating and shuffling the suitcase so much that it flips over and hitting him with the bat. We've covered this ground. Aggravated assault, aggravated battery, 2 independent forcible felonies. She's committing false imprisonment. She is the initial aggressor after there being no overt act. She can't start it and then say, well, I'm in fear of retaliation, because that's what her testimony was, is once I started doing these things, once I wouldn't let him out of the suitcase, I was afraid he would come out and harm me or kill me. Well, Judge, if I pull a gun on you, and I say, give me everything you own on you right now, and then you, in turn, pull a gun on me and say, bam, 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 and shoot and kill me, and I shoot, let me strike that, you pull a gun on me to defend yourself, and then I shoot and kill you, I can't assert self-defense. I can't say, well, Judge Kranick pulled a gun on me and I was in fear of death, because I was the initial aggressor, I was committing a forcible felony. That's the facts of this case here, according to her previous testimony. And the state concedes if she wants to change her testimony again, that's one thing, and then we'll cross that bridge when we get there. But if she testifies as she previously has, the court has already ruled there's no overt act, and you've read the transcripts, you know what she has said.
Judge, she hasn't testified. She hasn't testified. Dr. Harper's testified, Dr. Warner's testified.
They have not testified. They've given depositions.
Well, given depositions, but she hasn't testified about the act in question. She hasn't testified about the event in question. She had consultations and evaluations by Dr. Harper where they had discussions that Dr. Harper could relate in her testimony. Dr. Warner can say what was said during the evaluation. Again, both of those were not reported. There may be disputes. I disagree with his characterization of that assessment, but it's up to Sarah to tell the truth here today. She's under oath. She's under oath today. she's got an obligation to tell the truth. If he thinks she's made prior inconsistent statements, it's up to him to impeach her with those inconsistent statements.
To the extent that you are requesting permission to go into presumably and seemingly prior bad acts, vis-a-vis, he got the wine, and I know what happens when he gets it, and everything that follows from that, those are bad acts. That is character. And the Florida Supreme Court has provided guidance and circumstances, specifically in Holland, on what needs to be done. You're attempting to provide information that the defendant was apprehensive of the victim at the time of the homicide by virtue of the wine, etc., as you've proffered. That's bad character evidence that you're going to be bringing in. Historic bad character evidence. This is what happens when he drinks. This is what happens when I don't placate him. This is the situation that I find myself in, which inevitably may dovetail into prior incidents of abuse. That's all prohibited character under 404, 9404. And the carve out for that is if a overt act is established. It's not a subjective standard, it's an objective standard. The jury instruction, 3.6F, identifies it being an objective standard, and the Akendo case specifically tells us that it's an objective standard. In Akendo, the second DCA in 2023 stated, the conduct of a person acting in self-defense is measured by an objective standard, but the standard must be applied to the facts and circumstances as they appeared at the time of the altercation to the one acting in self-defense. I'm going to rely on Holland. Holland is the law of the land. It is what the Supreme Court has told us to utilize. That's what I will be relying on. The overt act has to be established.
Ms. Boone, do you understand that?
I do.
Okay. Anything else?
We cannot talk about any prior bad acts or anything of that nature until we talk about the actual event, the attack. Correct? You understand?
Do you understand that?
I do.
Okay. Anything else, State?
No, thank you.
Defense, anything else, sir?
No, sir.
All right, let's go ahead and stand and bring in our jury.